green card denials are about to spike. Here's why. Effective immediately, a sudden rule change under the Trump administration is catching thousands of green card applicants off guard. If you're applying for permanent residency or even thinking about it, this one document, just one form, could get your entire application denied. And worst of all, there's no warning, no grace period, no second chances. Let's break it down. What just changed? On June 11th, 2025, U.S. Citizenship and Immigration Services, USCIS, implemented a sweeping new policy requiring all green card applicants to submit a renewed Form I-693, the official immigration medical examination and vaccination record. Until now, many applicants could reuse a previously submitted I-693 for months, even years, as long as it remained valid. That's over. Now your I-693 must be current and directly linked to the application you're submitting. If your green card application is withdrawn, denied, or refiled, even for small reasons, your previous I-693 is now invalid. You'll need to get a brand new medical exam. No exceptions. What is Form I-693? Form I-693 is not just paperwork, it's a full medical clearance. Every applicant for a green card must prove they're not a public health risk. Here's what the form includes: a complete physical by a USCIS-approved civil surgeon, a TB, tuberculosis test, proof of vaccinations, MMR, hepatitis, tetanus, COVID, etc., screening for infectious diseases like syphilis, gonorrhea, and others. Without it, your application can't move forward. No grace period, not even 24 hours. What's alarming is the lack of transition time. This rule was enforced immediately. That means applications mailed this week could already be invalid. USCIS will reject any outdated I-693. There's no grandfathering in of older medicals, and no appeal for being unaware. The Trump administration is making it clear: only applicants who follow every instruction perfectly will move forward. The financial burden is real. This policy isn't just about red tape, it's about money. A single I-693 medical exam can cost anywhere between $100 and $500 depending on your location and provider. Now imagine having to do that twice, or 3 times. Once for your initial green card filing, again if you need to refile, and again if there's a delay or withdrawal. That's hundreds of dollars on top of already high legal fees, USCIS filing costs, and document translation expenses. For many immigrants and families, this is more than a hassle. It's a financial barrier. Who's affected by this? The answer is simple: everyone. This policy hits immigrants currently applying for a green card, those planning to apply soon, anyone with a pending Form I-485 adjustment of status, even applicants for certain visas at USCIS's discretion. If you already submitted your I-693 earlier this year, it might now be considered expired under the new rule. Worse, many applicants don't even know the policy changed. Immigration lawyers are warning that this could lead to a wave of denials and a growing backlog of resubmissions. Why did USCIS do this? USCIS released a statement explaining the change. According to the agency, the previous policy from April 2024, which allowed indefinite reuse of a valid I-693, was too broad and posed a public health risk. Their reasoning: we ensure that aliens get timely and proper medical examinations and treatment, which safeguards public health. Critics say it's a stretch, especially when no outbreaks or safety issues were tied to reused I-693s. Trump's message: residency is a privilege. President Trump and Secretary of State Marco Rubio have both repeated the same phrase. Permanent residency is a privilege, not a right. That tone has become central to immigration enforcement in 2025. It's not just about keeping undocumented immigrants out. It's about tightening the process, even for legal applicants. Every step, every document, every test must be perfect, or you risk starting over. Real case: green card holder detained. Let's not forget, USCIS and IC have been revoking green cards too. Earlier this year, Mahmoud Khalil, a green card holder and Columbia graduate, was detained for participating in a protest that the government said violated U.S. foreign policy. Despite being a lawful permanent resident, he was placed into removal proceedings. The message is clear. Having a green card does not guarantee safety. On June 20th, 2025, after 104 days in a Louisiana ICE detention center, federal judge Michael Farbiars ordered Khalil's release on bond. The judge ruled Khalil was neither a flight risk nor a danger, citing constitutional concerns and dismissing the government's national security rationale. Khalil left the detention facility the same day and reunited with his U.S. citizen wife and their newborn son, marking an emotional homecoming. Consequences of the new rule. This new medical exam policy could lead to thousands of rejected green card applications, long wait times for appointments with USCIS-approved civil surgeons, extra delays in family reunification, confusion and misinformation as applicants scramble to comply, and possibly legal battles as advocacy groups challenge the fairness of sudden changes without notice. Immigrants are being asked to navigate a maze where one wrong step can cost you your future. Timeline of the policy change. Here's how fast things moved. By April 2024, policy allowed indefinite reuse of signed I-693s. June 11th, 2025, Trump administration reverses that rule, effective immediately. July 3rd, 2025, new version of Form I-693 becomes mandatory. No grace period given for current applicants mid-process. One more barrier. For many immigrants, the process is already hard. The wait is long, the fees are high, the rules keep changing. Now, this medical form update adds one more obstacle. Even if you did everything right, one outdated form can ruin it all. Families may have to start over, not because they broke the law, but because the system moved the finish line again. What should you do now? If you're currently applying or plan to apply for a green card, check your Form I-693 immediately. Make sure it was signed after June 11th, 2025. If you're reapplying or refiling, you need a brand new exam. Call a USCIS-approved civil surgeon and book early. Delays are expected. Don't assume anything. Double-check the latest rules on the USCIS website. Also, talk to an immigration lawyer before submitting anything. Final thoughts. This is the new reality of U.S. immigration in 2025. Rules are changing faster than ever, and many of those changes, like this one, are taking effect without warning. Form I-693 may seem like just another paper, but it could decide whether your future in the U.S. moves forward or stops cold. Stay informed, stay prepared, and as always, we've got you covered right here. If you found this video helpful, please like, subscribe, and turn on the notification bell so you don't miss our next update. Thanks for watching, and we'll see you in the next one.